Be my guest.
Ok, allora sì, il tema di oggi, possiamo anche cominciare, quindi il tema di oggi è la mediazione obbligatoria, e l'idea è di capire un po' negli Stati Uniti, visto che sono almeno 20-30 anni avanti come esperienza, qual è stata la traiettoria, per capire perché il punto di partenza e l'opinione diffusa in Italia è che non ci possa essere un futuro della mediazione se non attraverso l'obbligatorietà. E Baruch ricordava che una decina d'anni fa, se non di più, no, 2015, quindi meno di 10 anni fa, il nostro connazionale Giuseppe De Palo, che probabilmente conoscete, ha fatto un gran chiasso ad una conferenza negli Stati Uniti parlando della mediazione come la bella addormentata, the sleeping beauty. The English people talked about the sleeping giant, I recall this metaphor. E Baruch è intervenuto e ha anche scritto un pezzo su una rivista che magari se tiro fuori da qualche parte ve la mando. Ok.
And let me just say, so Alessandra, it's much nicer than Lexmill. I also want to remind or share with you that one of my law school professors, a long time ago, 1972 or 3, whichever year I took his course, was one of your countrymen, Mauro Capelletti.
Lui ha studiato con Mauro Cappelletti all'inizio degli anni 70.
And he introduced me to mediation, and as part of his course in comparative law. So, and I actually worked for him in Firenze as a research assistant after law school. A wonderful, wonderful man, and himself a disciple of Piero Calamandrei. He quoted in his writing, and I quote from my students, Calamandrei's statement that if you want to know the character of a country, study its procedure.
E lui appunto ha studiato con Cappelletti e con Calamandrei, di Calamandrei ricorda in particolare questo suo, come dire, questa sua frase famosa, che se vuoi conoscere com'è un paese realmente, studia le sue regole procedurali.
Yep. So let me jump into this by putting my conclusion up front.
Okay.
So the question is for those of us, and I'm including you because Carlo brought you together, and I'm assuming because there is some connection to the transformative approach to mediation for all of you.
Yeah.
And the transformative approach emphasizes the absolute sanctity, I would say, of party self-determination in mediation. This is the essence, the fundamental principle, as ethical codes put it, of mediation, party self-determination. So if mediation is mandatory, so what does a transformative mediator do? And that's the question I'm starting with.
Permettetemi di anticipare le conclusioni prima di spiegare il mio ragionamento al riguardo. Come sapete, l'approccio trasformativo mette come principio essenziale quello dell'autodeterminazione delle parti. Ora, se la mediazione è obbligatoria, che ci sta a fare un mediatore trasformativo?
Right. So I'm often asked this question because in the larger context, in the United States, as De Paolo argued should be the case in Europe, much of mediation is mandatory, is obligatory, at least at the first stage, meaning the parties will come to the court and the court will order them to attend a mediation.
Il fatto è che sia negli Stati Uniti che in Italia la maggior parte della mediazione è obbligatoria, almeno nella sua prima fase, vale a dire che sono i giudici che mandano in mediazione le parti, oppure devono andarci per una qualche altra causa.
Right. The judge doesn't say, maybe you want to go to mediation. The judge says, go to mediation. And if you don't, you can't continue in my court. So that's the way the large share of mediation is conducted in this country, except in the large network of so-called community mediation centers. Community mediation centers have a long tradition of, taking people who walk in by themselves voluntarily from the street and conducting mediations.
Negli Stati Uniti la maggior parte delle mediazioni quindi arriva perché un giudice dice dovete andare in mediazione, non è che li invita, li suggerisce, gli offre come possibilità, dice andate. Fa eccezione a questo, diciamo, questo fenomeno, il fenomeno della cosiddetta mediazione comunitaria, dove invece abbiamo la gente che viene e liberamente opta per avere una mediazione.
Right. This, by the way, these community mediation centers, this was my introduction practically to mediation. How many years ago? 50 in 1974.
50.
Yeah, 50. That's I'm prematurely gray, but not really. So I started such a center in San Francisco in 1974, and ran it for several years. So and many people who became career mediators in this country did in the past and still do begin their practice as a volunteer mediator in a community mediation center.
E io personalmente ho cominciato a fare mediazione, a conoscere la mediazione, a parte questo, diciamo, l'esperienza teorica con Cappelletti a Firenze, però ho cominciato a fare mediazione 50 anni fa, quindi nel 74, a San Francisco, proprio in centri di mediazione comunitaria. E i centri di mediazione comunitaria hanno generato anche un sacco di altra gente che pratica come mediatore adesso.
And mediation in those centers then 50 years ago and still and throughout the period between has always been what we call facilitative mediation, either settlement driven mediation or at best problem solving mediation. Transformative mediation has not played a major role in that very, very large network across the whole country of these kinds of centers.
You meant the
Community
yeah.
the community centers.
E anche all'interno della mediazione, diciamo, comunitaria, diciamo, l'approccio più praticato è quello cosiddetto facilitativo, e questo comprende sia la mediazione che sia tesa al raggiungimento di un accordo, e la mediazione trasformativa resta tutto sommato minoritaria.
Right. So I keep making parentheses in my comments. And when I say facilitative mediation, what I mean, what I think is the reality, in facilitative mediation, mediators often do not respect party self-determination in many ways. In terms of the process, I run the process. You can decide if you like the result or not. That's the principle of facilitative mediation. So the mediator decides for the parties many things that are going to happen in mediation. And if you have studied at all with Carlo or anybody else, transformative mediation, you'll realize that is the opposite of the way that we conduct mediation in the transformative approach. We really do believe in and respect party self-determination about everything. So there's a big emphasis in mediation, whether voluntary or mandatory, in this country, that mediation is controlled, directed by the mediator.
Lasciatemi aprire una parentesi. Per mediazione facilitativa intendo anche quella in cui il più delle volte il mediatore adotta un atteggiamento direttivo, nel senso che dirige le parti. Il mantra è quello che io controllo il processo, voi controllate l'accordo, voi siete responsabili per l'accordo. Ma questo significa avere una certa direttività. Ecco, l'approccio trasformativo invece, come sapete bene, rifugge questo perché mette l'autodeterminazione delle parti prima di tutto, sia nella determinazione dell'accordo, ovviamente se c'è accordo, ma anche sulla procedura, su anche come muoversi. Quindi non controllo il processo.
I'm amazed at how much I understand of what you're saying, Carlo.
Really? Okay.
Yes, I do. I follow you very well, but I couldn't say one word by myself in Italian, except va bene.
Va bene.
Okay, va bene. So now, coming to the conclusion, I said I was going to put forward, and I didn't. If one adopts mandatory mediation, in other words, you have to go, then, as I also wrote in an article a long time ago, then if the mediation is the facilitative, directive, mediator-controlled approach, then you are sending the parties to a place where not only must they participate, not only is their participation not voluntary, but when they get to the mediation, much of what they must do there is also not voluntary. It's not controlled by themselves. It's not a matter of self-determination, whether we yell or scream, whether we have ground rules, whether we have quote-unquote caucuses. None of that is our decision. Those decisions are all made by the mediator. So it's now become a mandatory entry into mediation, and then a mandatory participation in a process not controlled by myself. That's two mandatories stacked one on the other. It very much violates the principle of self-determination on which mediation is supposedly based.
Quindi, di fatto, se il mediatore adotta un atteggiamento appunto di controllo sul procedimento, chiamiamolo facilitativo, indipendentemente dal fatto che la mediazione sia obbligatoria o meno, ma a maggior ragione, ancora di più, se la mediazione è obbligatoria, le parti sono, come dire, costrette in ogni caso a non avere la libertà di muoversi come pensano sia meglio. Prima di tutto perché debbono fare una mediazione, e secondo perché quando la fanno e vanno in mediazione si trovano incanalate in quello che il mediatore gli dice di fare.
So my conclusion long ago was, there is nothing wrong with creating a system of mandatory mediation, meaning you must go. Whoever it is that sends you there, you must go. But the only legitimate way then for mediation to function is in a transformative model,
Quindi,
in which one... Okay?
sì, quindi la conclusione mia è che non c'è niente di male in fondo nel mettere in piedi un sistema di mediazione obbligatoria, cioè di dire andate alla mediazione perché dovete farla, eccetera. Quello che è importante è invece quello che succede in mediazione.
Right. In mediation, unless we're to do away entirely with the principle of self-determination, in mediation, the mediator must conduct a transformative session, a session based on party self-determination, party choice about whether there are ground rules and what they are, choice about what topics to discuss and in what order, choice about whether to have private meetings or not, choice about everything that occurs. If that's the kind of mediation that is actually being conducted, then I don't think it matters that the parties have been sent there, quote unquote, as a matter of obligation to go. It's fine.
Quindi può, tutto sommato, è accettabile il fatto di un sistema che preveda mediazione obbligatoria, secondo Baruch. Quello che conta è come la mediazione viene condotta, perché lì sì è importante che il mediatore si muova in un'ottica trasformativa nel senso di rispettare la libera autodeterminazione delle parti.
So actually, this was my conclusion a long time ago. It's still my conclusion. It's also, I believe, what explains the situation that DePaolo and others have addressed, which is parties don't come voluntarily to mediation. And if they do come one time, somebody recommended it to them, they don't come back. There's no such thing, I don't think anywhere, as repeat customers to the mediation process. The reason is when they get there, they find basically some streamlined version of the judicial process.
Yeah.
I have a judge running the thing, and he tells me how to talk and when to talk and what to say and what not to say. And eventually I do have a veto over the resolution, which the mediator is pushing for generally. That's true. I have a veto. People rarely exercise that veto. And the reason is because the process itself propels them into accepting it. But whether or not that's the dynamic, the fact is we thought mediation was going to be so wonderful that everybody would flock to our doors. And once having come, would flock to them again. Guess what? Never happened. Not in this country, not in Europe, not in Italy, as far as I understand from the presentations of DePaolo and others. Why not? Why didn't it prove to be a wonderful boon that everybody wanted more of once they had a taste? It didn't do that. Yeah.
Da entusiasti della mediazione noi ci aspettiamo che la gente non voglia che risolvere in mediazione i problemi che ha, quindi che ci sia un affollamento delle domande, delle richieste di mediazione, e questo non capita né negli Stati Uniti né in Italia né da altre parti che lui conosca. La ragione qual è per Baruch? La ragione è data essenzialmente dalla cattiva esperienza che la gente matura il più delle volte in mediazione. Vale a dire, se tu ti trovi in una situazione che è più o meno quella di un processo, dove non puoi parlare poco, sei controllato e così via, come fai poi a ritornarci o a consigliare ad altri di andare?
So, for me, it is not a crucial thing that a court system or an administrator or a private business adopts a policy of mandatory mediation. You must go to mediation. At least try it, right? I don't think that's a problem. I think there's actually a good argument for that. The argument is people don't know what it is. So you have to push them into it so that they find out, they have a first taste of what it is. However, that doesn't mean they have to stay. So as a matter of fact, DePaolo says that the policy that he recommends is what's called an easy opt-out. You have to go, you have to show up, But if you don't want to be there, you can leave. That's apparently, I'm not sure whether that's the policy in Italy now. I'm not sure whether it's the policy anywhere. But if that's the policy, no big deal. But once you're there and you decide to stay, what is the dish that is served at that restaurant?
Ok, ok, quindi in conclusione, nell'opinione di Baruch non è così terribile un sistema che prevede l'obbligatorietà di una mediazione, soprattutto prendendo spunto da quello che De Paolo appunto aveva proposto, ed era il famoso primo incontro, cioè la possibilità di un opt-out facile, poter uscire facilmente. Now things are changed in Italy as far as the opt-out is concerned. E quello che conta invece è come la mediazione viene condotta. Ok, I have some doubts anyway.
One sec.
Doubt.
One sec.
Sorry.
So let me just finish.
Yeah, sorry.
The key question is, what dish does this restaurant serve? If it serves directive, mediator-controlled mediation, my view is nobody's coming back for a second meal. They may as well go to court.
Il problema quindi è il menù. Se il primo piatto è buono, la gente ordina anche il secondo. Se invece il primo piatto fa schifo, la gente si alza e se ne va.
If the restaurant is serving a process that is built on and actually uses and actually practices party self-determination, people will come back. And this is what we basically say. So my thinking on the subject is, what matters is not so much whether you tell people whether to come or not. What matters is what is the flavor of the dish that you serve them when they come. If it's not a transformative, a party-centered approach to the practice, people will not come. You won't be supporting party self-determination. And you may as well just let people go to small claims courts or whatever. And a transformative mediator, I don't know if anyone checks up on you. When I first started doing things in a community mediation center years ago, no one came in and watched what I did. So once the parties came, because they were told they had to, if I wanted to conduct a transformative party-centered mediation session, always giving the parties the right to choose as they walk through the process, if I wanted to do that, no one stopped me. And therefore, I think that's what a transformative mediator can and must and should say today. Fine, have mandatory mediation. Send people to me. What I'm going to do is what I'm going to do. I'm going to practice mediation as a process that is based on, all the way through, party self-determination. I don't think that no one will stop me. No one will check up on me. If none of my cases, quote unquote, settle, that probably won't be true. But even if many of my cases don't settle, but people walk out and they're thrilled because they had the opportunity to make choices for themselves, to decide what to do and how to do it, they will go out and they'll fill a satisfaction survey. Excellent, 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 excellent. What more can that institution want than a lot of very, very satisfied parties?
Nella sua esperienza come mediatore, appunto, avviata 50 anni fa presso questi community center, Baruch ha raccontato come le cose funzionano un po' in realtà come stiamo facendo noi, vale a dire che noi andiamo avanti e pratichiamo a nostro modo. la gente è contenta, nessuno controlla quello che si fa, nel senso che non è che pretendano che tu debba costringere le parti a muoversi in un certo modo. Quindi, in parole povere, la pratica trasformativa può essere benissimo coerente anche ad un sistema obbligatorio.
I have to be, I'm sorry, go ahead.
No, okay.
I want to be completely honest. I have to be, because a lot of what I say is in black and white in print. You can look me up and see. When I first started community mediation in 1976, I did not know anything but the facilitative controlling approach. It wasn't until I started a mediation center at Hofstra Law School with Joe Folger in about 1990 that he and I both, quote unquote, discovered.
1990.
1990, yeah. We discovered, oh, you know what? You can practice differently. You can actually do self-determination. So my transformative practice and teaching history dates from then. That's about 35 years, not 50. But for 35 years, this is what we have taught and done and taught others to do and joined others in doing, hopefully like yourselves. And if we do that as mediators, I don't think it matters that the people who are sending clients to us are sending them on an obligatory basis. Because what we're doing is reversing that and encouraging party self-determination.
Sì, anche l'esperienza che Baruch riporta, l'esperienza personale assomiglia a quella di molti di noi, vale a dire all'inizio abbiamo praticato un po' tutti come, non tutti, un po' tutti, come mediatori facilitativi, nel senso di visto sopra, e in fondo la pratica trasformativa, la riflessione sulla bontà della pratica trasformativa è nata proprio dall'esperienza con le persone. Quindi si è visto che poi le persone erano più contente, più soddisfatte quando venivano lasciate liberi di decidere del loro destino, delle loro cose, di come muoversi e così via. Ok, very
I
interesting.
think, yeah, no, I think I said enough on the topic, and maybe you have comments and questions, and we can take time for that.
Ok, perfetto, abbiamo mezz'oretta scarsa e quindi secondo me abbiamo il tempo di esplorare alcune cose. Intanto sarebbe interessante se voi voleste riportare la vostra esperienza pratica, ecco, in questo, perché io, Alessandra, con cui mi vedo spesso, ci confrontiamo, Sabrina, eccetera, le conosciamo queste dinamiche, ma altri magari no, e quindi è importante. E poi avevo due punti in particolare che volevo io rivolgere a Baruch, che riguardano i pericoli legati alla mediazione obbligatoria. Ok, let me start. Before people reporting their own experience that more or less is similar to yours, I would like to make some thoughts about what I perceive as a dangerous situation. That means you said that a mandatory system is not per se really a tragedy. I fear I'm not sure about that, because there is, firstly, one simple reason. When you establish a mandatory system, you have to also establish a system for recording the fact that the people has undergone a mediation in order to to do something else. That means you need some piece of paper saying, we have tried, but unfortunately we did not succeed, and so we are here in front of you, judge. Okay. And this simple fact means that there is a bureaucracy behind that. There is a paperwork and somebody who has to fill some forms, somebody who, a notary, and the risk in that is that you have to establish a controlling system, a channeling system. And this is particularly true in Italy because they, for example, have decided that only some certified center, mediation center, has the authority to release this piece of paper. And so they created a hierarchy among mediation centers, the authorized one and the non-authorized one. And the second step was the provision for a mandatory presence of lawyers, because lawyers are sort of official witness of the correctness of the process. And so the inherent risk for all this system is an over-lawyering system with everything that is connected to that. So this is my impression. So of course, those are risks that you can avoid in some way. For example, in establishing a very simple paper process system, et cetera, et cetera. But it's really too risky to undertake this way. A third dangerous aspect is the connection between the judicial world and the mediation world. Inevitably, even if we say that there is impermeability among the two, inevitably the judge want to know what happened in mediation. Why did it not settle? Was maybe because one party was unreasonably not willing to do that, eccetera, eccetera.
Yeah.
Riassumendo in italiano, io vedo tre grandi pericoli nel sistema della mediazione obbligatoria. Prima di tutto devi, per forza di cose, mettere in piedi un sistema che certifichi che hai fatto una mediazione e che quindi hai il pezzo di carta, il famoso verbale, diciamola. E quindi noi sappiamo bene com'è andata sotto questo aspetto. La seconda è la presenza degli avvocati che processualizzano il tutto e rendono la cosa molto simile a un tribunale. La terza è la connessione fra il mondo giudiziario e il mondo della mediazione, in cui il giudice vuole mettere il naso per sapere come sono andate le cose in mediazione.
Well, those are three definite dangers or bad dangers if they would happen. Let me work them backwards, okay? The last one first. If judges want to know what happened and why there's no settlement, for example, somebody needs to train the judges to tell them, or actually to challenge them, to say that is a fundamental violation of judicial ethics. The whole nature is that the process, forget about if it's not self-determination or it is confidentiality. How is it possible? A judge can ask questions about what happened inside the session because she wants to know who blocked the settlement. That's a terrible It may be a danger, Carlo. It's a danger that ought to be stopped by someone bringing a complaint for violation of judicial ethics.
Sì,
However,
sono in effetti tre grossi pericoli. Se prendiamo dall'ultimo, quello che il giudice ficchi il naso, insomma, in quello che è avvenuto nella mediazione, potrebbe essere neutralizzato dal fatto di fargli presente che facendo così viola il principio di confidenzialità.
a judge says to the parties, I'm sending you this session. It's a confidential conversation you're having in order to reach a settlement. And then I, as judge, break the confidentiality of that session. I'm not saying that isn't a danger that may happen. That has to be stopped. But there's another side to the closeness of the two systems, Carlo, and that is it's an opportunity for you as mediators to educate and influence the judges. For example, this I know, at least some mediation centers here in the US, which have many cases that come to them from the courts, have a very close relationship with the courts and have used it to educate judges about what is possible in mediation and to educate them about the importance of party self-determination.
Sì.
And attitudes on the part of the judges have changed.
Sì, la cosa buona è che questa dà la possibilità ai mediatori di, come dire, spiegare ai giudici cosa in realtà è la mediazione e quindi fare un'opera chiamiamola di educazione, di istruzione.
The second problem, I don't know if I understood you. The system in Italy at the moment requires that lawyers or a lawyer be actually in attendance at the mediation?
Most of the time, yes.
Not representing the parties, but in a sense monitoring the behavior of the mediator?
They are there, they are present, they are there, they occupy most of the air. And so
they talk?
They control the party, they talk most largely more
You're
than
saying
the
that
client.
they're there as representatives of the parties.
They
And that's required. It's required that parties have lawyers in mediation.
Yes.
Well, that's first of all, and by the way, do the parties have a right to say, no, I don't want you?
It's required by the law.
It's required by the law. Well, somebody has to do something to change that law. That's a bad idea. No question. That's a bad idea. Not because people shouldn't be allowed to choose to bring a lawyer to mediation.
No, absolutely.
But to require the parties to have lawyers and then turn the mediation into a lawyered mediation where the lawyers speak mostly. So and again, it's an opportunity, but a very difficult one for you to educate the lawyers. You know, if those lawyers are coming from some panel somewhere, you ought to invite those lawyers to a training session in transformative mediation, Carlo, and let them learn about something other than directed, settlement-oriented mediation. But that's a terrible system to require parties to have lawyers. That I agree with.
Sì, l'aspetto della presenza obbligatoria degli avvocati per Baruch, credo abbiate capito, è decisamente negativa, però anche questa è un'occasione per, come dire, fare un'opera di promozione, di educazione presso gli stessi avvocati.
Why, let me ask you, what is the rationale of those who authored the law and the system? What is their rationale for requiring lawyers to be present and to speak for the parties? What's their reasoning?
Theoretically, is the need for the party to have a protection against themselves. That means self-injured damage. practically it was the result of an action by the lobby of the lawyers.
Terrible. But
Yeah.
the very existence of this requirement is an obvious violation of the belief in the principle of self-determination, right? The principle of self-determination has to include my right to do something stupid. If I don't have the right to make a bad decision,
Yeah.
I don't have the right to self-determination.
Absolutely. There are exceptions, of course. For example, disputes about consumers matters or non-mandatory mediation cases, but this is very a little portion of the.
Is this true only for Italy, or this is the pan-European system now?
No, absolutely, only for Italy.
Only for Italy. Those lawyers must have a great lobby.
Yeah, yeah.
Wow.
Yeah, I guess we are 80% of the member of the parliaments, something like that.
Right,
70 or
right.
something like that.
I have no easy answer to that question, except to say that that is a big barrier to the whole principle of party self-determination, isn't it?
Yeah.
You can't speak for yourself unless I'm there to tell you to shut up and say what you ought to have said instead. Whoa. Even in the US, and we also have a lot of lawyers, I don't know of a mediation program anywhere that imposes this requirement. Maybe I'm wrong. I may be off, but that's very, very difficult for a transformative mediator to function in that environment. Unless, so let me try this out on you, okay? If I'm a transformative mediator and I am, conducting a mediation in that system, I might, when, one side speaks primarily through his or her lawyer, I guess that's what happens, right? So I might, in effect, offer the party herself or himself a check-in to say, is that what you want to say, what your lawyer just said? Does that represent what you're thinking? And or would you like to add anything to that? Do you have a different point of view? That's dangerous itself for the mediator to step in between the lawyer and the client. I don't usually recommend that. But in this kind of a system, you can imagine if you're brave enough as a transformative mediator to do that, and see what happens.
Yeah, that is something that we currently do.
You do that.
Yeah.
And what happens? What happens?
Well, sometimes the party jumps in and is satisfied and talk. But for example, yesterday I had a mediation. Sorry, I had a mediation, and it was online, and the screen was occupied by a lawyer and his two clients, two females. And when I asked the parties if they want to add something to what the lawyer said, a woman jumped in, but unfortunately it was the one out of the screen. And so he started talking, and he talked for quite a while, but everybody just was hearing her voice, not seeing her face. And so other times the invitation produced nothing, apparently, and the people keep staying quiet and silent.
Right. Well, the truth is that, again, if you believe strongly in this idea of party self-determination, so as a party, with a lawyer, whether or not I wanted that lawyer there in the first place or not, I have the right to decide whether to step in and override my lawyer or to follow the lead of my lawyer. And whichever happens, I have that opportunity and I've taken that opportunity. And to that extent, you as a mediator have done your job. You fulfilled your role there of holding the opportunity for parties to make decisions, including on what they want their lawyers to do and not do. But that's a pretty bad system, I would say.
Yeah. Mario has written a remarks on the chat. Would you like to elaborate that?
In inglese o in italiano?
Come vuoi.
Just a small remark. Hello, Baruch. Thank you for being here. I have the feeling that you understood that in the Italian mediation, the parties have to speak through the lawyers. Just correct me if I got it wrong, but it's not really like that. I mean, they are obliged to be assisted by a lawyer in mediation. And it's true that in many cases, lawyers tend to overshadow the client, but the client is not, in the position to talk through the lawyer. It depends on how the mediator frames the mediation. It depends on how the mediator describe what mediation is. So it mostly depends on the mediator work, whether the parties can speak for themselves or speak through the lawyer. Many of us have an approach which is, I'm not giving you a rule, just whoever wants to speak is welcome. Feel free to speak anytime. If you are more comfortable to speak through your lawyer, that's fine. I mean, it's your choice. Our role is to give you some choices. Just wanted to make sure that you did not get as a factual information that we have to do mediation with lawyers in the presence of the parties. It's the opposite. I mean,
puoi dirlo in italiano? Puoi dirlo in italiano a beneficio.
Sì, no, dicevo solo che sostanzialmente è vero che le parti devono essere assistite dagli avvocati, per la legge dice così, ma non che le parti devono parlare attraverso gli avvocati, che mi sembrava un po' il concetto che stesse passando dal feedback che Baruch stava dando, ma è un'impressione mia. Quindi dipende da come il mediatore fa il suo lavoro, quindi ci sono quelli che amano, come dire, far parlare gli avvocati, altri che lasciano liberi tutti di fare tutto quello che vogliono, altri che invece impongono delle regole, dipende, ecco, però volevo solo far passare il concetto che non c'è un automatismo tra assistenza del legale e legale che parla per conto della parte necessariamente, ecco, come requisito di legge.
Right. So that certainly is a more, I'm looking for the right word, but more and more these days, I can't find the right word when I want it. That's certainly a more favorable system for party self-determination. The fact is, it depends not just on how the mediator conducts the session, but how the lawyer has established his or her relationship with the client. Because the lawyer may already have dominated that interaction to the extent that, the client is not going to take that opportunity that you present for them as a mediator. But still, that does exactly, again, the aim of the transformative intervener is to allow the opportunities for party choice, no matter how constrained that environment can be. And it can be pretty constrained, as you explained, in an institutionalized system. But you can't take away the constraints of the system. What you can do is to optimize opportunities for party choice within those constraints. And that's what you just described. So that if I've done that as a mediator and the party is consistently deferring to the lawyer, that doesn't mean that I've taken those choices away. It means they're choosing to defer to their lawyer. At some points, I may want to check in with them directly and see, do they want to say anything or not? But I think that our job is to maximize party choice, which is what you're describing. I do think that, again, when mediators do that, let me put it the other way around. I can imagine a mediation session in which, not only can I imagine it, I've seen them, where the mediator says to the lawyer who is talking the whole time, and the mediator says, you know, I want you to stay silent for now. I want to hear from your client directly. So please.
Let me recap in Italian.
Otherwise
we'll. Sì, il discorso di Baruch è questo. Anche in una situazione difficile come questa, comunque possiamo fare il nostro lavoro nell'ottica di supportare la libera determinazione delle parti. Immaginate una sessione di mediazione dove gli avvocati parlano sempre solo loro.
Right. So if there's a mediator, and this is what I think probably many mediators would do, says, Mr. Lawyer, Ms. Lawyer, please take a few steps back. I want to hear from your client. I don't want to hear this in your words. I want to hear directly from your client. Please let me hear from your client.
Immaginate che il mediatore intervenga e dica, per favore avvocati, un attimo, per favore state zitti voi che voglio sentire cosa dicono le parti.
Now you're not going to do that as a transformative mediator.
Un mediatore trasformativo non fa questo.
No. So now you have a lawyer who, in two different cases, in one of them, the mediator is a transformative mediator, and the other, the mediator is a directive, controlling mediator. So you now, as a lawyer, have had the experience of two different versions of the mediation process, right? Which one would you like better as a lawyer? I'm assuming...
Da avvocato preferite avere a che fare con un mediatore appunto che dirige il processo, oppure con un mediatore trasformativo che vi lascia liberi di intervenire come decidete voi?
So you make you also have the chance to not just affect the views of the judges about what mediation should really look like, but also the lawyers. Because I think the lawyers will get the point pretty quickly. Hey, I'd rather have a mediator who supports party choices than a mediator who tells everybody what to do in the sessions. I don't know what happens in those sessions, but I can't imagine that most mediators don't actually say, please be quiet, let me hear directly from your client.
Yeah. In this respect, I would like to ask Alessandra, e poi ti do la parola a Mario, di raccontarci quello che mi hai detto della mediazione di ieri, perché è esattamente questo il caso. I asked Alessandra to say something about the mediation he told me about yesterday, because it was exactly this case.
This case.
Quello relativo al dialogo tra una parte e l'avvocato.
Sì.
Sì, mi sono trovata in una mediazione in cui, diciamo, i protagonisti erano un commercialista e il suo ex collaboratore. Il commercialista ha preso la parola subito, quindi anche c'era il suo legale, ma ha parlato sempre lui, ha esposto, raccontando come si erano svolti i fatti. E dall'altra parte c'era l'avvocata e il collaboratore che era quasi nascosto anche fisicamente, no? Dall'avvocata, ma io credo anche per una sua scelta, non solo perché l'avvocata glielo avesse imposto. E ovviamente rispondeva diciamo, ai solleciti del commercialista, ma con due modalità differenti, perché il commercialista parlava dei fatti effettivamente accaduti. L'avvocata parlava ovviamente sul piano giuridico e quindi il dialogo era molto difficile, come dire.
E tu che cosa hai fatto?
Sì, a un certo momento, vabbè, ho rispecchiato quello che diceva, che hanno detto entrambi, e a un certo momento ho chiesto al collaboratore che non parlava se aveva qualcosa da dire, e questo effettivamente ha detto sì, ha detto
Let
poco.
me, fammi riassumere a beneficio di Baruch.
Eh,
Well, the case was a dispute among a professional, a senior professional, who asked to mediate a case against a former associate, young associate, who left the office, bring some clients with him as well, and above all, left a lot of work undone. So in the professional head, that's created a lot of damage. And so he was asking money for that. And the session began with a professional assisted by his lawyer, and the young associate assisted by a lady lawyer. And soon the conversation was only between the professional himself, who was speaking a lot and explain all his anger and his everything, and the associate's lawyer, who was rebacking in legal terms, just in legal terms, with the associate hidden behind her and not saying a word. So at a certain point, Alessandra reflected and summarized the conversation and offered the chance for the associate to say something. Would you like to add something? And what he said, e che cosa ha detto il giovane associato?
Sì, diciamo, ha detto di essere dispiaciuto della situazione e quindi che, insomma, che questa cosa gli pesava molto. Ha detto poco in realtà, però comunque ha espresso il suo dispiacere
Ok.
non dico scusato, ma quasi, insomma.
Ok.
Vedo che Mario deve andare via, quindi magari se gli facciamo dire quello che voleva dire velocemente.
And the young associate said just few words. I'm sorry. I didn't mean that. And then he kept silent again. But I bet there was a shift in that.
So the one thing that the associate spoke up was to say, "I'm sorry."
I'm sorry.
Yeah, that's interesting.
And that was totally divergent from what his lawyer had been keeping.
Right. The lawyer was not apologizing or
Absolutely
expressing
not.
any. Yeah, absolutely not. Okay, so I have to say I'm going to have to put a limit to this because I have another meeting coming up soon. But
Mario.
Again, this is showing what you can accomplish even in the most constrained circumstances, because that clearly was something that well, I'm not sure. I can't say that. I was going to say that's something that a directive mediator would not have done, or they would have done something different. But what you did, you were the mediator, Alessandra. Is that right?
Yeah.
Alessandra is the mediator. What you did, exactly opened up that opportunity for something that, and really, you allowed the angry senior professional to be angry, and you know, and you allowed the junior party to let their attorney make a legalistic defense, but you also opened the opportunity for they themselves to add something else, which they did. So it seems to me you conducted yourself perfectly appropriately in the circumstances, and that it probably had an impact. Again, not just on the parties, but on the lawyers. And that was my point about this, that you, in your role as mediator, in that room, doing what you do, can do something that is different than what a conventional facilitative, directive, settlement-oriented mediator would do, and often actually do, and that will make a difference. It will make a difference to the parties. It will make a difference to the lawyers. It will make a difference to the judges. And the difference that it will make is worth making. The difference that it will make is making the principle of self-determination an actuality and not just a principle. A principle that doesn't manifest in actuality is no principle at all. You're the ones who have the opportunities to make that principle real. That's my conclusion.
Mario, vuoi chiudere tu? Con la tua-
Yes, I would like to speak a lot on these topics. Just wondering, how about picking up this conversation again in the near future, Baruch? What
I'm
do you think?
available.
You're
I'm
available.
available. I enjoy speaking with you folks a lot, and plus I get to practice my Italian comprehension,
Okay.
if not expression.
Okay. So thank you very much. I think we time is out now, but I promise I can organize something similar in the next week. So whenever Baruch is available, and thank you very much for today's conversation.
And
Always
thanks to you.
interesting.
I'm sorry that I could not address more questions, but I think we had some good ones here at the end. And Adolfo, I'm not sure what you're thinking about, or Daniela, because I didn't hear from you, or Sabrina, or Adriana, but I hope that this was useful to all of you. And I
Okay.
appreciate the chance to talk with you.
Grazie mille. Grazie a
Okay,
tutti. Alla prossima. Thank you. Bye.
be well. Bye-bye.
Ciao, grazie.